what are some of the common mistakes that you have seen people making when they write a succession planning?
One of the most common mistakes that people that make a will is that they do not have a list of all their assets and liabilities clearly listed. Once you know the extent of your assets is when you can actually sit down and prepare um, uh, uh, a will, because otherwise, you might have some bank account somewhere, some demat account, some shares scattered around, and which you do not deal in your will. So to make it comprehensive, you must first of all create a list of all your assets and also your liabilities, because your liabilities will also need to be knocked off against the inheritance that the legal heirs will get. The most important thing to keep in mind when you're writing a will is that you must get a comprehensive list of all the assets and liabilities that one has. So there could be a demat account which you've forgotten, or there are some assets, some jewellery that's lying somewhere in some locker, which is not accounted for, some digital assets that you may have, which you may not want to ignore. So get all of that in one place before you write a will. You must also update all your records, in case there are insurance policies. Many times what happens is nominees have passed away, and we've not corrected those records. So all that, and records, new children that have been born into the family, grandchildren. You must make sure that your will updates and is ready to take care of all the extensions or reductions that in terms of the family members that would have happened, and never underestimate the complications of tax liabilities that are there. And you must have a tax advisor or a financial advisor that advises you on the tax matters, and what is something that will give you the most benefit here. The most important part is you must communicate of your intention of how the property will devolve upon the legal heirs, or people that you would want to pass on the property to. Have an open communication so that there is no ambiguity, because the disputes would come in case there is ambiguity. So the fewer the ambiguity, the better it would be after your death for these properties to be distributed, and greater acceptance.